Good morning, everybody. I hope you're doing well. We are going to be listening to oral arguments a little bit later today, but the great thing is I can pause them when I do them later like this. So we're ready to go. We're going to be listening to a Blanche v. Lau this morning, which is a case involving immigration and the deportation of lawful permanent residents when they try to re-enter and if they have a crime. So, without further ado, let's get ready to go. Give it just a sec. Sorry, I'm having to use the YouTube, so. Just a minute. Let's see. Come on. Don't be dumb.
We will hear argument this morning in case 25-429, Blanche versus Lau. Mr. Joshi?
Mr. Chief Justice, and may it please the Court. When Respondent arrived in the United States in June of 2012, he had, in fact, already committed a crime involving moral turpitude. That meant, under the INA, he was, in fact, seeking an admission, and thus was, in fact, eligible for parole and correctly charged with inadmissibility. And what's more, the government proved everything I just said by clear and convincing evidence in Respondent's removal proceedings. Yet Respondent now seeks to vacate his removal order on the ground that immigration officers at the airport in June of 2012 did not themselves, in that moment, possess that clear and convincing evidence. That makes no sense. Burdens of proof and evidentiary burdens are things that apply in adversarial proceedings before a decision maker, not at the airport where non-lawyer immigration officers are processing hundreds, maybe thousands of arrivals a day. Unsurprisingly, Respondent has identified no text, no historical practice, and no precedent imposing an at-the-border clear and convincing evidentiary requirement. Instead, Respondent largely focuses on a distraction. He says that DHS immigration officers can't parole him without first determining that he's seeking an admission.
Good morning, everybody coming in.
We're
listening to an immigration
just not
case.
with the
just
clear
got
and convincing evidence
Blanche
that
v.
he
Lau.
prefers. So Respondent's argument really just begs the question in this case. Similarly, he says the clear and convincing evidence that DHS presented in the removal proceedings amounts to post hoc justification. But again, that assumes the conclusion that the border officers needed clear and convincing evidence in the first place. Now, we have other arguments that parole decisions are not reviewable and that even an incorrect parole can't be treated as an admission.
I think that seems reasonable.
You don't have to reach those. Respondent's failure to establish his at-the-border clear and convincing evidentiary requirement dooms his case and is sufficient on its own to reverse the judgment below. I welcome the Court's questions.
I know you're making a distinction between the clear and convincing at the border as opposed to at the hearing. But where does clear and convincing come from? Is it in the INA?
No, it is a board decision that has determined that because the INA requires an applicant for admission to establish admissibility by clear and convincing evidence, but on the other hand requires the government to establish deportability by clear and convincing evidence. The board has sort of looked at those and decided that the threshold question about which one of those two paths it should go down
he was already
is the
a lawful
government's
permanent
burden,
resident.
and said clear and convincing seems to be the right standard, and we've accepted that for purposes of this case.
But it's not in the statute itself.
It's not directly in the statute.
So has the board applied that standard at the border?
No, never. In fact, the board was quite clear in Valenzuela Felix that it does not apply at the border. It rejected the precise argument that Respondent is making here today.
Counsel, the statute says an alien lawfully admitted for permanent residence in the United States shall not be regarded as seeking an admission into the U.S. unless the alien has done one of six things, okay? So it's not an alien seeking admission unless it's done one of those six things. So the question becomes, if the U.S. decides that there's a possibility that any group of aliens might have a conviction or might have committed a crime of moral turpitude. The basis for that, well, for any reason the government they can think of, okay? And just willy-nilly paroles LPRs, people with green cards, into the U.S. and says, we're just not going to let you be admitted. We're going to take away your green card. You're going to get it stamped, a stamped card with temporary admission. Is that reviewable?
Eventually, if removal proceedings are initiated, the government will have to show by clear and convincing evidence that, in fact, one of those 6 criteria applied.
So this statutory command is meaningless at the border. Aliens who possess a green card will be considered applicants for admission at the whim.
She said you ain't got shit.
I don't think that's quite correct. First of all,
because if what you're saying to me is that the law saying that they're entitled to come in and be removed under 1227 as opposed to 1182 doesn't apply, why bother with the statutory assumption?
So I don't think that it's just at the whim. First of all, there's a...
No, I don't think it's at the whim. But my point still remains, if it's not reviewable, it can be.
And what I'm saying is that the determination about whether the LPR, in fact, satisfied one of those 6 criteria in the statute is decided afresh by the immigration judge in removal proceedings.
What's the difference between 1184 and 1227? You can remove an LPR who has been convicted of a crime of moral turpitude under 1227. So why do you need 1184?
1182, yeah.
I'm sorry, I misspoke.
No, I understood. Respondent happens to be removal under both, but there is an important difference in not just crimes involving moral turpitude, but others. But for the crimes involving moral turpitude in particular, an alien is inadmissible if he commits such a crime at any time after admission.
If you're coming in, we're listening to an immigration
if he commits such a crime within 5 years after his admission. Now, the happenstance is respondent happened to have committed his crime 4 years and 6 months after admission.
I can pause
so it turns out by happenstance we're lucky in respondent's case that it doesn't matter, but that's not going to be true of other LPRs. In addition, there are many other differences between admissibility and deportability. Let me give you one example that doesn't apply here, but applies to a lot of cases, and that is drug trafficking offenses. To be deportable under 1227, there's got to be a conviction. It's only commission under 1182 for inadmissibility. And I know what you're thinking, the difference between commission and conviction, but that's not the reason it's so important to us, because generally we wait for the conviction before trying to remove them. The reason it's important is the categorical approach. Because 1227 requires the conviction.
I'm sorry, I'm going to pause right there. I want you all to understand what he just said. Generally, we wait for a conviction. That's wild. Just generally, they wait. Like, why would you not be waiting? I mean, if it's an issue of deportability, right? If it's an issue of deportability, certainly they should be convicted in a court of law if you're going to make this claim. I mean, that's just my opinion.
There are a lot of state offenses where their list of controlled substances is slightly broader than the federal list of controlled substances. So convictions we can't rely on, but commission we can, because we can say, oh, it was actually cocaine, not this like esoteric
I guess the problem I'm having is LPRs have a legal right to be here. They have a legal right to come back into the country, and Congress is the one who deems the situations in which that right should be taken away from them. So why should it matter? Meaning, why should a temporary removal take away their constitutional right to have that judgment decided under 1227 as opposed to under 1182?
So first, it is not a constitutional right to be deported rather than deemed inadmissible.
It is. You're right. It's a statutory right.
Right.
But they have that statutory right. So why should that right be taken away?
So I just want to be clear. If when removal proceedings are initiated and the government says we can remove under 1182 as opposed to 1227, the government will have to prove that that is in fact the correct choice by clear and convincing evidence.
But Mr. Joshi, what happens in the meantime? Then, because this really is, as I understand Mr. Lau's argument, it is about timing, whether it has to happen at the border or whether it would happen in the removal proceeding, this threshold determination. What is the consequence for an LPR that is paroled? Do they lose some sort of rights because they have this flag on their status until the removal proceeding begins?
No. A parole maintains the alien status. The LPR remains an LPR status. I know that some of respondents amici say that, you know, the temporary I-551, which is the temporary green card, is not as convincing to employers as a permanent green card, but in the eyes of the law, it's identical status. In fact, even the temporary green cards, they tend to say expires after 1 year.
I hate this shit.
We don't think that expiration means anything. They're still an LPR.
So why are there green cards?
I'm sorry, I'm not quite finished. So you think there's practical consequences, but as a matter of law, there's no legal consequence. The determination is still going to happen. What is the length of time, typically, between paroling and then the initiation of removal proceedings?
It depends. So typically what happens,
give me 1 second,
and
Kelly.
as a matter of practice, I think this is pretty
And you're
uniform.
welcome if you want to come up, Law. We're just going through this. I'm a little bit late this morning, so I can pause. Kelly, lawful permanent resident. So hope that helps. But you're welcome, Law.
Is when an LPR is paroled for a deferred inspection or prosecution, as in this case, they're instructed to report to a deferred inspection station, which is a different location, in 30 days. And then when they just to evaluate what's going on. And then there'll be periodic check-ins, rarely, if ever, longer than 90 days. But it'll basically be tied to the pending criminal proceedings, and they'll just check in and say, okay,
well,
we're
you can
at
still
pretrial
come up if
discovery,
you're
we're
traveling.
At, now trial is expected to be at this
you
time
can
or
just
the
sit
other,
up here and
we'll
look
typically
pretty.
just wait until the proceedings have finished. I think this case is probably fairly typical. They tend to close out within about a year if there's a pending charge, you know, speedy trial and all of that, but that's fairly typical.
Mr. Joshi, you suggest that there's no difference, but I'm wondering then, why is the green card removed from the person if they are paroled?
I don't know the answer to that.
All right, so obviously the government is doing something
This is
to
Jackson.
parolees. They're giving them a different card than the one they had. And we have amici that say that without the permanent card, which the person previously had, there is real uncertainty about their status as a practical matter, that their employment becomes tenuous, that their schooling, I'm referring to the brief of the Asian American Legal Defense and Education Fund. So we have those practical difficulties. And then I'm wondering, doesn't parole status then put the person in a category that they are eligible for removal? Whereas if they had been admitted, then based on a subsequent conviction, the government would have had to deport them. And the burdens are different with respect to removability versus deportability. Isn't that right?
Yeah, so if I could answer both of those
I
questions.
mean, that's a legal consequence. It does matter whether you're brought back in as a parolee or you're admitted as a lawful permanent resident.
If you're paroled, it's as if you're still standing at the border. So yes, it keeps open the possibility of removal on inadmissibility grounds in addition to deportability.
Okay, so it
grounds.
does make a difference. And so the question then becomes, looking at the statutes that Justice Sotomayor pointed out, if a lawful permanent resident under the statute is supposed to be brought in or let in as admitted, unless 6 different possibilities for turning that person.
I just want to say this. Listen, I don't like pretend to have any express understanding of the parolee system. Like, this is not the claim I'm making. But when I worked with the state in vaccines, we had to deal with parolee systems for Ukrainian refugees, I believe, and then some of the people from Afghanistan. That system is complicated and weird as fuck. And I just needed to weigh in that it's just such a dog shit system. But anyway, okay, we're getting back into it. I'm sorry. I had to get off on a tangent.
Into a parolee rather than an admittee. I'm wondering why the government's position is that the determination of any of those 6 categories doesn't have to happen at the time in which the border person is making a determination about this person's admissibility. I think your argument is at some point later in the future, we can decide whether or not the person fits into one of those 6 categories. But it would seem to me that that's a prerequisite to the initial assessment as to whether or not they come
law
in
said parolees
as
have no
admitted, or
protected
they come
status,
in
can
as
be
a
removed at
parolee,
the
which
whim of
we've
the
determined makes
executive.
a difference.
Yes, so I want to
I
tease
just
out
hate
2
the
concepts
system
here. You
itself. It's
said we can
weird.
decide at a later time whether he fits into one of those 6 categories. That's not quite right. We decide in the removal proceedings,
Justin,
rather
it's
the
likely
immigration
gonna be in
judge
June.
decides in the removal proceeding. It's the government burden to prove that the alien in the past fit, past tense, into one
I
of those 6
understand,
categories.
but timing matters because at the border, you're making the determination as to whether or not this person comes in under the lawful permanent resident admitted status or whether they're coming in as a parolee. And if that decision turns on the assessment of the 6 categories, I would think it would have to be done at that time.
Yes, but not with clear and convincing evidence. That's a thing that applies in removal proceedings before a neutral decision maker.
So what is the standard at the time?
So let me give you a 3-part answer to that. The first is I'm going to tell you that we don't think there is a standard. The second is I'm going to say if you insist on one, what it is, and it's going to involve satisfaction of satisfactory evidence to the
You
border
don't
officer.
think there's a
And then the third, I'm going to
standard?
try and respond to what I anticipate will be your response to my first 2 answers.
Because that would be because the first 2 won't sound very good?
No, they'll sound fine. They'll just lead to
Love me some
a point
Kagan.
that some of the amici, respondents amici make. So my first point is that burdens of proof are just not something we think about as applicable in a border environment where an officer, as I said, it's typically an adversarial proceeding with the decision makers where you have burdens of proof. If you take away one of the adversaries, we typically don't talk about burdens of proof. We say like prima facie case or something.
Can I just stop you for a second though, because you're caught up in assessing whether or not there's a burden of proof. I'm just trying to understand how the border officer is to make the determination that this person is let in as a lawful permanent resident versus a parolee.
So,
and whether we call it burdens of proof or what, that's fine, and we don't think about it in those terms, but they have to have some standard, and what is it?
Okay, so I'll jump to my second point then, which is the standard is, we think, because the INA doesn't speak directly to this issue or impose any kind of burden, the standard would be the same standard that is longstanding and traditional in immigration law, even predating the INA, going back a century or more, which is when the sovereign controls who enters the country at the border, it's the person arriving has to establish to the satisfaction of the officer that they are entitled to be let in. This court in Sing Tuck, I think it's a 1904 case, used the word satisfactory. The INA codifies this principle in places. I think Section 1361, it says established to the satisfaction of the border officer. Our regulations 235.1
okay, and this
that we
person, the person at the...
You're swinging for the fences here. In this case, the respondent was charged with a criminal offense at the time.
I think this is Alito.
Come back to the United States. Is that correct?
Correct.
And the question that is before us is whether that had to be shown at the border by clear and convincing evidence.
Sweet,
Whether the
thanks,
commission of
Law.
the offense, yes.
Now, the statute says has committed. It doesn't say may have
When in
committed.
doubt, just listen for him
It
to
also
say
doesn't
for.
say has been convicted,
And I know it's Alito.
which is language that appears in the provision to which a cross-reference is made. But something has to be determined at the border. Right now, the Third Circuit said it's probable cause. You think that's too high?
I I understand that the Third Circuit has said that and it has derived it from kind of due process avoidance. I don't know that it really makes sense to just pull probable cause out of the air and
I
import
like
it.
that
I
you
think
brought that
you
up.
just decided a case earlier
I was actually I'll pause and talk about that. I like that you brought that up. The satisfaction by what metric? Is they entirely subjective? If so, are they trained by some metric? Well, that's the question here. Just saying like you have to satisfy this. Oh God, that sounds dirty, but just to say like you have to satisfy the guard, to like let them let you in. Okay, but what kind of satisfaction? Like what are we talking about? And yeah, I would say that's important. Okay, but are there metrics for this? Is there certain criteria? Like we know with asylum, they have to have the credible fear interview with oh God, I can't remember. Law's better at this one than I am. But, like what are the metrics that they're using? I like that you brought that up because I was thinking about that. USCIS. Thank you, Law. I appreciate you. You should really come up here and just look pretty. You don't have to talk, but anyway, okay.
Term in which you refuse to just blindly impose probable cause on, I think it was warrantless searches for emergency aid. And I think, that would certainly be better than the Second Circuit's rule, and we could, certainly try and live with that. But I think the right answer is the background immigration rule of to the satisfaction. And let me spell out.
So what if the immigration officer just says, you look very shifty. I think that you have committed a criminal
That's a valid
offense,
question.
And therefore, you cannot be admitted. You're going to be paroled.
Yeah, that would be wrong. That would be an officer acting in bad faith. But let me try and reassure you that you shouldn't have your interpretation of the INA turn on that kind of assumption. Number one, immigration officers, line officers are not authorized to grant parole.
He didn't turn it. You did. You
said the head of the court or a supervisor of a certain
admitting.
GS level. Second, as I was mentioning to Justice Barrett, this kind of parole requires a check-in at 30 days and periodic.
Alito
Those are
and Thomas
at separate
both chimed
stations
in.
manned by different officers. My understanding is it's usually rotating officers. So you would have to think that if this is going to be long-lasting or anything other than a very temporary, defeasible decision made by one rogue officer, that's just not true. And you would have to think the entire agency is acting in bad faith. And more than that, you would have to think they're acting in bad faith in a way that imposes more work on themselves. I mean, if the LPR is clearly ought to be let in, DHS is not going to keep paroling him in bad faith when it requires their officers to do more work.
Could I just ask you a practical question? And you may well not have this information, but in practice, are people treated the way respondent was treated if they have not already been charged with a criminal offense? How would the immigration
listen, man. Sometimes I gotta give Alito his due. These are good
under
questions.
Investigation someplace.
Yeah, as a practical matter,
no discernible standards.
At least not in Clause 5, which is the one we've been talking about. I can imagine a circumstance in Clause 3, which says that's the one that says if the LPR is engaged in criminal activity overseas. I think if there's like an Interpol alert, I think that's a circumstance where that's not even a charge. That's just law enforcement saying we think this LPR might have engaged in criminal activity overseas. We think that would be an adequate basis for the border officer to determine that the LPR engaged in criminal activity and therefore to parole him. If and when removal proceedings are launched.
Hey guys, just a quick thing. Sorry, I have to do the, shameless plug. If you're in here, if you can just tap the screen, it helps so much. Help fill out the gift goals, or at least maybe do the hand heart thing. I don't really give a fuck about any of the other stuff, but yeah, do the shit so TikTok doesn't get mad at me and suppress it. I appreciate you, and we will get back into it.
DHS, the government, is going to have to prove by clear and convincing evidence that, in fact, at that time, the LPR did engage in the criminal activity.
I guess what seems a little mysterious is that once you admit that much, that there is a clear and convincing evidence standard, and that standard is what applies not to the removal, right? It's what applies to the reentry, so that the IOJ at the removal proceeding is going to be thinking about this past question about how the person should have been classified at the reentry. Once that becomes the appropriate inquiry or the inquiry that's relevant in this case, why the standard shouldn't apply at the time that inquiry is like right in front of you when the person has re-entered.
Kagan,
For
I
the
just wanna
same
bend her
reason
over.
that you
That was-
don't apply the beyond a reasonable doubt standard at the indictment or at the filing of a criminal information. That's a standard that applies in the ultimate proceeding to determine ultimate innocence or guilt in the criminal case. And in the removal proceeding, the reason the IJ looks at it
Well, that would be true. Like, I understand that if that's the way you look at it, this is kind of the charging stage and that's the adjudication stage. But it does seem like the questions, it seems bizarre that the adjudication stage would sort of look back and ask the question about reentry. Usually when we're talking about charging and adjudication, the ultimate question is the one that's decided at adjudication. You're not looking back to some prior question. Once you have to look back to some prior question, why aren't you just applying the standard there?
Kagan is on this
two
shit.
things. The first thing I'll say is you're not, I just want to be clear about this. The IJ is not reviewing the immigration officer's decision. The IJ is taking a fresh look at the evidence and determining whether, in fact, the LPRs fit one of those 6 categories. So that's number one. Number two, the reason for that oddity is actually just when you stare at the INA long enough, you realize that that has to be how it is because number one, the INA says, and this is 1229.
Hey, Law, just a quick question. Can you watch the chat for
page
just a
5A
second?
of our opening
I just
brief,
have to run to
that
my
the
door
removal
real quick.
proceedings, setting aside expedited removal, are the sole and exclusive
I know you're in
procedure
the
for determining
traveling, so I don't want to.
admissibility or removability. And then later, it's and earlier in A1, it says that the immigration
Okay,
judge is
I'll just speak on for a sec.
determining whether he
I
can
need
be
a snack.
deported or removed. And then later in E2, this is on page 6A to 7A of our opening brief, it defines removable in terms of in the case of an alien not admitted and in the case of an alien admitted. And it's that threshold thing, which is actually part of the removability determination, is what the IJ is doing. It just so happens in the case of an LPR in this circumstance that when the LPR comes in, he is admitted or not admitted, depending on whether he satisfies one of these 6 exceptions. And parole, in that case, when the LPR is paroled, it's like hitting a pause button and saying, let's pause things. It's as if the line at Newark Airport took a year for him to get to the front of the line. And so it's just this weird confluence of things is why the IJ is looking backward in point of time, but it is not at all to like review the DHS immigration officer's decision. And that's why you don't apply the burden of proof at the airport. And it just really would be weird to do that because Congress in IRIRA clearly wanted LPRs to be treated just like any other alien in these 6 circumstances. Congress surely knew that the border environment where there are just hundreds, thousands of people a day, I mean, to give you a sense of perspective, every year, approximately, actually a little over 8 million LPRs enter the United States, and those 8 million LPRs affect 40 million separate entries, so an average of 5 apiece. And it would sort of be unthinkable for Congress to think that the border officer in the moment, just with people coming through the line, is going to have clear and convincing evidence without doing, in Justice Ginsburg's memorial phrase, convening a pie powder court.
Well, you would, though, wouldn't you? Because you could just check.
I'm sorry, and maybe I'm just crazy, but is he making the argument that, let's say I'm an LPR and I'm returning to the country and I'm coming through, a border check line in an airport. It's just, right? Is he making the argument that the border agent should just be able to tell me to fuck off? Like, is that the argument I'm hearing? I'm confused, and I'm legitimately asking a question. This is a law question. Is this the argument he's making? Like, long story short?
Conviction records, and that's the way it would work. If somebody has already been convicted, you would be put in one pipeline. If the person had not already been convicted, you would be put in another pipeline. And yes, would that miss some people, maybe like the respondent here, but, close enough for government work.
So I don't think that's right because
Okay, law said, if Border Patrol has fifis, you're inadmissible. They can parole you in instead of let you in under LPR rights. Oh, okay. That makes a lot more sense here. But what the fuck? That's crazy. Okay, I got you, Law. Thank you. Sorry, I was hearing it wrong then because when I tried to do a little bit of background on this, like it was all over the place. So I want to make sure I'm understanding what I'm hearing. So, okay, thank you.
Because it would really undermine Congress's pretty considered choice to partially abrogate and expand upon and pull back, curtail, I should say, the Flutie doctrine. Because Congress very clearly chose to say committed an offense, not is inadmissible under the provision. What's more, it happens that crimes involving moral turpitude and I think some controlled substances offenses require a conviction or admission of guilt for inadmissibility, but most of the crimes do not. Drug trafficking, human trafficking, prostitution, they don't require a conviction. So too with the overseas criminal activity. You would really be gutting all 6 of these provisions and really just not giving effect to what Congress seemed to want to do really, really strongly in IRIRA.
Thank you, counsel. Justice Thomas?
Mr. Yoshi, how was the offense here determined at the border?
At the border, it was because of the pending charge.
And where was that? I mean, what did the Border Patrol have before him or her?
The immigration officer searching a federal database in which states can put in their criminal charges and things like that, searched that and found the.
Sorry, I'm trying to do 800 things right now. Dolphin, okay, so to remove a lawful permanent resident who committed an offense listed in Section 1182A and was subsequently paroled into the United States, must the government prove that it possessed clear and convincing evidence of the offense at the time of the lawful permanent resident's last re-entry into the United States. That's what we're talking about this morning.
Arrest and pending charge that respondent was facing at that time.
And that basically said the offense had been committed by this person.
The border officer, in good faith, concluded that that was the answer, yes. In the same way that the prosecutor who filed the charge, I mean, we always think this when prosecutors file charges or seek indictments, that the prosecutor, in good faith, believes, I think you did it, and I think I'm going to be able to prove to a jury that you did it. And the border officer is making exactly those same conclusions, and he's entitled to credit the prosecutors.
Well, the only point I'm making is that it wasn't arbitrary. It came from a database, and that seems to somehow be lost here.
Yes, that's entirely correct. And indeed, respondent and his amici have had every incentive to go find examples of bad faith paroles where we're willy-nilly paroling LPRs, and they just haven't found any because we don't do that. It's not in our interest to do that.
So was this process challenged before the removal hearing?
No, this was raised at the removal hearing where we concededly.
So whatever burdens that the parole imposed were not challenged before the removal.
That's right. In fairness, I'm not sure there's a path to judicial review for it, but that is correct.
Yeah. Justice Alito, Justice Sotomayor.
You're presuming something I can't. You're presuming. Well, let me start with. You didn't have proof at the moment he presented himself that he had committed a crime of moral turpitude, right?
I know, all right. That's what I heard too.
So
but I was
think
like,
the
all right,
charge is enough for an officer to conclude.
But could you have excluded him? With the charge alone.
I see. Because it's a crime involving moral turpitude, no, but but there are many other offenses listed in 1182A2 for which we could have. The vast majority of them don't require a conviction to be removable as inadmissible. So, for example, if the pending charge had been...
I want to go just with this one because that's the issue. Could you have, at the time that he was at the border, could you statutorily have excluded him for having committed a crime of moral turpitude on the basis of the charge alone?
The border officer, as a
Thank you,
practical
law.
matter,
Conviction
they
required
don't
for
do this,
crime
but
of moral turpitude.
nothing forecloses the officer. I'm going to answer you directly. Nothing would have foreclosed DHS at that moment from initiating removal proceedings, potentially detaining him under 1226, and by the time of the hearing before the IJ, we would have to prove that, in fact, he was seeking an admission when he arrived at the airport.
I'm sorry. What you're saying is, yes, that you had enough proof to bar his admission?
I'm not saying that we would have won in front of the immigration judge. What I'm saying...
I just answered the question.
Well, that is my
Did
answer.
you have a right at the border? Did you have enough proof that he had committed a crime of moral turpitude?
The border officer made a conclusion that he had.
On what basis?
That he had probable cause to believe?
That the border officer concluded that respondent
Could he have gone to a hearing at that time and won?
I don't know. By the time of a hearing, we would have probably gathered additional evidence.
At that moment, if he had gone to a hearing, could he have won?
She's holding his feet to the fire.
Hearing, we would have a
counsel at that moment, and this is a decision at issue.
I don't know.
At that moment, could he prove it?
I don't know what hearing you're referring to.
I'm not. At the moment he made the decision.
At the moment he made the decision, the border officer...
Did he have enough proof?
The border officer...
Did he have enough proof?
It's yes or no.
At that moment, forget...
For whom?
For him.
Yes, the border officer had enough proof for himself.
To do what? Parole him or
yes.
to exclude him?
Sorry. We're going to stop. We're not going to slide past that.
I'm not sure what you mean by exclude.
What he just said. He said he had enough proof. The border agent had enough proof for himself. Are we using our subjective fifis to let people into the country now? Is that what we're fucking doing? Is this where we're at? I swear to fucking God. Okay, I'm gonna shut the fuck up. I'm gonna shut up.
You could have just said you're not admissible. Bye.
Yes, but then that would
and
require...
now parole him.
That would require initiating removal proceedings, and as I said earlier...
And so at that moment, if there was an IJ there sitting there, he could not have won that removal, correct?
Probably not.
Okay.
Because we have a clear and convincing burden.
I'm sorry, maybe would you like to finish that answer?
Thank you. In a removal proceeding, which is where this would be adjudicated, so if the officer thought he was inadmissible, he would hand him a notice to appear and say, you are being charged as inadmissible because you have, committed a crime involving moral turpitude. And the IJ is sitting right there, and the IJ would say, great, we're now in removal proceedings. Government, you have to prove that, in fact, he was seeking an admission by clear and convincing evidence. Do you have it? And the answer is no, which is the whole reason we're fighting this case, is because border officers are rarely going to be able to collect clear and convincing evidence.
What Justice Sullivan said is allowing DHS to defer a parole eligibility determination and take a wait-and-see approach, contingent on whether a conviction eventually materializes, effectively nullifies the clear command that LPR should be admitted. That's the clear command of the statute. You've got to admit them unless they've done these 6 things. And you're admitting that at that moment, he may have reason to believe he committed these things, but you didn't have proof that he had committed those things.
Amen, Sotomayor. I love you.
With all respect to Judge Sullivan, he jumbled 2 things. He conflated the deferral of a decision on inadmissibility with a parole eligibility determination.
All right. Could I just ask you one final question?
Leave Justice Sullivan alone.
In what other administrative context, when an agency, and the agent is the agency here, makes a determination, do we permit them to develop new evidence after the decision they're charged with making is made? I thought that we only review the evidence they had at the time they made the decision.
Removal proceedings are themselves administrative proceedings, so yes, a court would review only the evidence presented at the removal proceeding.
Assuming that the parole was valid.
Let me find out.
Whether or not it's valid. Even if the parole's invalid, we would have to show that In fact, in reality, respondent was seeking an admission on June 15, 2012, when he landed at Newark Airport. We would have to prove that by clear and convincing evidence to an immigration judge, and we did.
Justice Kagan?
Mr. Joshi, am I right that your theory depends on the ability to parole the person coming in? You know, in other words, you're saying if you parole that person, everything is suspended until the IJ can get their hands on this determination. So everything really depends on the parole. Is that correct?
Yes and no. Our view is that once the immigration officer determines that he's satisfied or he is not satisfied that none of the 6 exceptions applies. So he says, I think you're seeking an admission, so I'm going to treat you just like any other arriving alien, even though you're an LPR. You still have your LPR status, but you're going to be inspected and have to prove your admissibility just like every other arriving alien. At that point, typically there are 3 options. 1 is admit. 2 is removal proceedings. And then the third, which is entirely in DHS's discretion, is parole, because I'm not sure if you actually are inadmissible, the final thing, or if you should be admitted. And so I'm going to parole to hit the pause button. We can both develop our evidence.
Okay, so that's close enough to a yes that I'm going to ask you my second question. Because the parole is the pressing of the pause button in this case.
Yes.
And the question is, what entitles you to press?
I'm so sorry. This crime of moral turpitude was, and I quote, this gets in it even better. The charging document alleged that the respondent, with the intent to defraud, sold $282,240 worth of shorts bearing a counterfeit mark in March 2012. That's why we're here. That's why we're fucking here. Oh my God. Sorry. And yes, from China.
Press that pause button. In other words, what entitles you to give parole before you've made the determination? Because as I understand it, you're only parole eligible if you've committed these various crimes, which sounds like a strange thing to say, like that you've committed the crimes and so you're parole eligible. But that's the truth of the matter. Right. And so don't you have to make the determination before you give parole? And then, since the determination is the trigger for the parole, which is what suspends the proceedings, it would seem as though you need to satisfy your burden before you give the parole.
I was with you until that very last point. So yes, there is a determination made, but it's not clear and convincing evidence. It is something lower than that by the nature of the border environment. And that's our critical submission here.
What?
Yeah, though then you've lost your kind of this is the charging stage
just
and that's the adjudication
lower than that.
Stage.
Doesn't matter what it is.
Because now what's critical is whether you've made the appropriate showing in order to grant parole, which is a different question than anything that the IG is going to have to face. And you're saying that in order to grant parole, all you need is kind of to the satisfaction of.
Correct. That is right. And that is how the rest of the INA works. If you're a citizen and you walk in and you say, I'm a citizen, you have to show that you are in fact a citizen to the border officer's satisfaction. And if you don't, you can be detained. That's the Singh Tuck case. It's court held. You can be detained and there's no problem with
that's
that.
going to be my new standard of proof.
Feature of the immigration
as
laws
your
is
paralegal,
that someone coming in has to establish
anytime,
to
I'm
the
just
satisfaction of the
something
officer
lower.
that he's allowed in. And
we're good.
The way that
the government
eventually gets
so.
litigated is in the removal proceeding when the government will bear the burden to show that historical fact was correct or incorrect. But that's where things get litigated. There's not a clear and convincing standard at the border.
Well, one last, just to pick up on something that you were saying with Justice Sotomayor, you were going to explain what you think Judge Sullivan got wrong. So tell me what you think Judge Sullivan got wrong.
So Judge Sullivan, in the passage that I think Justice Sotomayor was reading, said the government's not allowed to defer the parole eligibility determination. And I think you and I were just talking about that. We're not deferring that determination. It's just the border officer makes it with a certain level of confidence. And then in removal proceedings, the government has to prove that that the LPR was in fact seeking admission by a higher evidentiary standard in that adversarial proceeding and convince the immigration judge of it. So we're not deferring the parole eligibility, and I think he was jumbling deferral of the admissibility determination with the threshold question.
Got it. Thank you.
Justice Gorsuch?
Just a couple quick questions. Do we have to decide what the standard for parole is in this case? I mean, couldn't one simply say whether he was paroled lawfully or not he was paroled? And did you meet your burden in the removal proceedings? Answer that yes or no.
Exactly.
Okay. And then with respect to the parole decision, you say you're not sure whether that would be reviewable independently. Your friend on the other side, page 34 of his brief, says that it would be reviewable under 1252A2B as a question of law involving any decision or action in the discretion of the government. I can also see an argument perhaps that it might be reviewable under 704 of the APA for questions that are otherwise unreachable final agency actions. Thoughts?
Can we get Justice Gorsuch
so our
to
longstanding
read books
position of the government, as you might
I may not love him as a
parole
person,
decisions
but
are
his
not
voice is
reviewable either in a petition for review from a removal order or
No,
under
I'm not talking about through a petition involving the removal proceedings. I'm talking about could he have brought a distinct challenge under 1252? Could he have brought a distinct challenge under 704? To challenge the parole decision at the time or shortly after he came into the country.
Not even going to lie to you.
So
him and
our
Justice
longstanding
Thomas,
my
my favorite voices on the court.
I got that.
Just,
What do you say about
so
those
relaxing.
two statutory provisions?
Also know that
Do you have any reasons for no?
Yeah. So the reason is that under 1252 in the zipper clause, we think everything coming out of a removal proceeding has to be channeled to the removal proceeding, and this parole determination was. So then the question is, well, can he just bring a standalone APA action or an ultra vires action while he's on parole? And I'm not aware of that ever happening. This is the very odd case in which an alien doesn't want to be paroled. Usually they complain when we terminate their parole, and you've seen those cases. But it's very rare that an alien says, I don't want to be paroled. So we've never faced that situation. So we'll have to deal with it when it arises.
Justice Kavanaugh? Justice Barrett?
So, Mr. Joshi, I agree with you. This is a weird thing to think about at the border, a clear and convincing evidence standard applying because there is no adjudicatory proceeding. And it seems to me that, I mean, you've conceded for purposes of this case that a clear and convincing standard applies to that threshold admissibility, like which track you're on. It seems to me that, I mean, either that's wrong or when you're at the border, I'm trying to imagine if you lose this case, what happens and if it's actually more favorable to an LPR. Because it seems to me that if a clear and convincing standard applies when the LPR arrives, like, you know, as Mr. Lau did, if it's a clear and convincing standard and you really do want to apply, either you would have to gut it and say, well, we just can't show because it's impractical in the airport or at the border otherwise to show that there's clear and convincing evidence that someone engaged in criminal conduct abroad or, you know, committed a crime.
My bad. I'm sorry. I'm ranting. Sorry. I wanted to stop that for a second. Here's what I want you to think about. I hate it when they use that terminology like, oh, like it might be too tough to meet this metric, so we need to blah, 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 blah. Because, and I'm not saying Amy Coney Barrett did this, but I'm saying like this is the same administration that's arguing that you shouldn't need a warrant to bust into people's homes. They're like, nah, that's too high of a bar. No, bitch. We need to have a bar and meet it. Like, I'm sorry. This just drives me insane. We'll get back into it.
Crime, it doesn't say convicted. So you either just give it up and gut those provisions, or what do? Do you detain the LPRs and you set up some sort of adjudicatory proceeding? And how would that be judicially reviewable? How would we know whether the border officer had clear and convincing evidence? There'd be no administrative record.
Correct. That's exactly right. And that's why I think Justice Ginsburg and Vartelis, memorably said, you don't call into session a pie powder court. But that's essentially what we'd have to do if we were to enforce the seeking admission provision. The other alternative, I suppose, would just be to initiate removal proceedings, potentially detain him under 1226, and then use that time to gather the right evidence, but that doesn't really benefit anyone. Parole has a significant public benefit in these circumstances. It benefits the public because it means someone facing a criminal charge can be held responsible for his crimes. It benefits, in most instances, the LPR because they can organize their defense from within the country while they're free and not detained, and can maybe even plea bargain down to charges that don't carry immigration consequences. And it benefits the government because we don't have to have detention, fill up a detention bed with someone who's maybe otherwise safe, and we don't have to incur those expenses, and and both sides can gather the evidence they need for the.
So if you lose this case, and we say that yes, the Border Patrol officer has to have clear and convincing evidence, then detention of the returning LPR is a route that you might take.
In some cases, yes.
Some cases, yes.
Yeah.
So rather than being paroled, they might face detention
cases, yes.
and immediate
Let's
removal
be real.
proceedings.
That is
which
correct.
Would not benefit
Because by hypothesis, if we lose this case, parole would be taken off the table. So then we would be just facing the choice of admit them, even though the officer in good faith thinks they shouldn't be admitted, or initiate removal proceedings, detain them, and take our chances. It's not a great choice. That's why we've been doing this for so many years.
If you lose this case, are you going to challenge that the clear and convincing evidence standard applies? Because you've conceded it for purposes of this case, but the statute doesn't say it, which is another reason to think that there's not an adjudicatory proceeding contemplated.
I don't know the answer to that. Obviously, the Attorney General can himself take a BIA case and issue a decision, but I don't know the answer to that.
Okay, so that's another way in which a win for Mr. Lau might not have long-term benefit for aliens or LPRs seeking to return to the country.
I think that's right.
Okay.
Justice Jackson?
So, Mr. Joshi, I guess I am struggling to understand why parole is a significant public benefit. That was the conversation that you had with Justice Barrett right now. And I guess I start where the statute starts, which is the recognition that lawful permanent resident status is
when it's convenient
the
for them
standard
law
in immigration law.
I
These are
would
people
say
who
some
have gone
textuals are
through
pretty sound, but
the immigration
some of these are when it's convenient.
gauntlet and have achieved what is the next closest thing to citizenship status in terms of their ability to work, to live, to do things here in the United States. And they have left the country for the requisite amount of time, and they're returning, and the statute says that those people shall not be regarded as seeking an admission for the purpose of the immigration laws. That's the background, that this person has a green card and they're supposed to be let in. So I appreciate that your border officer might have some suspicions or might not want to bring them back, or might think, ooh, look, there's some evidence in a database somewhere that suggests that this person might be a problem. But this person, under the statute, is supposed to be let in. That's the beginning. So then the question becomes, to what extent can the border officer decide, in good faith or not, that this person is not going to be let in? That I'm deciding right now here at the border that despite your green card status, you have to not be admitted. And Congress was pretty clear that there are 6 and only 6 circumstances. One is that this person has committed an offense, and it doesn't just say has committed an offense, Border Patrol officer, you figure that out. It says has committed an offense identified in a particular section. And then when we go to that section, the person who is inadmissible under that section is one who is an alien convicted of or who admits having committed this offense.
Sing it, girl.
So I guess my question is, your busy border officer, under this statutory scheme, it seems to me he's supposed to say, I see here that you have been indicted, but the statute says a person is inadmissible if they're convicted of or admitted to. Those things don't exist. So the background rule of letting this person in is supposed to be what happens right now.
I agree, Law,
Now, if
but
that's
I'm
the
kind
case,
of
first
here
of all,
for
let me
it.
ask you, Is that the end of Mr. Lau's story? I mean, I thought he could still be deported.
I do like to watch them play the game
convicted
about
of this
what are we
crime that
doing
he's been
today?
accused of. He can still be deported, right?
In his particular circumstance, yes, but that will not be true of all LPRs. In his particular circumstance, it's the happenstance that he committed that crime 4 years and 6 months after admission, rather than 5 years and 1 month.
You're saying because of the statute of limitations, there may be right, but that's in Congress's purview as well. They've decided that a person who is beyond the 5 years, that should not be a reason to deport them. So I don't understand why the border officer suddenly has so much power to deprive a person who has a green card
this is a good
based
question.
on a suspicion or even an indictment when the statute seems to require conviction for this particular kind of exclusion.
Okay, so 2 things. First, the statute does not require conviction. This court, the difference between commission and conviction runs throughout the INA. This court recognized it in Barton against Barr. That is a difference. If Congress had intended to pick up the conviction for crimes involving moral turpitude, and not all of the offenses listed require a conviction, it would have just said inadmissible under 1182A2. Congress didn't say that. It said committed an offense.
So then the question becomes who decides committed an offense and when.
My ass.
Your rule is the Border Patrol officer gets to decide whether or not he's committed an offense, but you say it's a pause. We know he can't really do it. So we'll assume that it's okay for him to treat this person as inadmissible during the period of time in which we're figuring out whether or not he actually is. That's the government's position, right? You can parole him, meaning strip his green card, treat him as inadmissible for this period of time while we are determining whether or not he is actually inadmissible.
Parole does not change his status. He's still an LPR. I understand that the amici don't like the form of the government document that proves that he is still an LPR. They say that.
So will the government commit to letting the person keep their green card? You said you don't know why they take it. If that's true, then can they keep their green card?
I don't. I'm sure there are very good administrability reasons why we have to keep the green card. As it turns out, for example, one reason might be, I'm not saying this is the reason, but I am just aware of this fact that seems relevant, which is that of the LPRs who are paroled, approximately 25% are no-shows. They just don't show up to their deferred inspection. We can't find them.
Oh, so you're
that's
going to
probably a pretty good reason why we hang on to that.
All right, let me just finally really kind of drill down on the concern that I have. You said in your response to Justice Thomas that it really isn't in the government's interest to engage in sort of a bad faith paroling kind of scenario. And my concern is that I could actually see a world in which it would be in the government's interest. And it's a situation in which people who are lawful permanent residents who have green cards leave
violating the rights of the 75 or the 25 is this government
a suspicion or even an indictment that's in the government's control, they flag this person as being returning under parole as opposed to lawful admission. They take this person's green card, which then makes it much, much harder for this person to actually live and work and continue in their life here in the United States, perhaps so much so that this person self-deports because it's really, really difficult without a green card to operate in this country. So you could imagine a world in which a government that really is not interested in immigration and having immigrants here living and working could use this kind of thing to inappropriately parole people rather than admit them so that it depresses immigration. Can you respond to that?
I don't think this court should interpret the INA on the assumption that the entire executive branch is operating in bad faith.
Why the fuck not?
Thank you.
Thank you, counsel. Mr. Voretsky?
Oh, hell no. No. No, he did not just say, I don't think you should interpret the INA as though the entire executive is acting on bad faith. We've had ICE agents out here unaliving American citizens, multiple habeas, like I would say it's in the thousands of habeas petitions filed, wantonly violating people's rights. Border Patrol unalived Alex fucking Preddy in Minnesota. What the fuck? I'm sorry. I have to yell. I apologize. I'm losing my mind. Anyway, let's get back into it.
Mr. Chief Justice, and may it please the court. The court should either affirm or dig. The government came to this court with a dispute about when it must meet its burden to prove that a lawful permanent resident may be treated as seeking an admission to the United States, at the border or before an IJ. Only now, in its merits reply and here today, does the government say the case is about the burden of proof, a question that it forfeited before the Second Circuit and conceded in its cert reply was not contested. The INA's text and structure, plus historical practice, make clear that an officer must decide at the border whether an LPR is seeking an admission. And at the cert stage, Mr. Lau argued that this case was a poor vehicle because the government had not briefed the standard for that determination and the Second Circuit hadn't decided it. In response, at page 11 of the government's cert reply, it said, quote, "The government is not challenging the clear and convincing evidence standard. This case is about when the government must carry that burden." On that understanding, the principal merits briefs focused solely on timing until the government changed the question in its reply brief. At page 2 of the merits reply, the government says, quote, that the timing issue is not in dispute because whether an LPR is seeking an admission must be determined at the border. The government now claims that, quote, the requisite level of proof is the crux of the dispute in this case. What is that requisite level of proof? Something lower than clear and convincing evidence, maybe satisfaction, maybe probable cause. None of that has been briefed. So much for square corners in a case about square corners. Even putting aside gamesmanship, the court shouldn't decide the burden question without full briefing and a lower court decision. The court thus should affirm on timing alone or alternatively dig. Doing so would not be disruptive. Border agents can determine whether a returning LPR can be regarded as seeking an admission using their ordinary interview and background check techniques. And because the Second Circuit didn't decide the burden question, because again, the government failed to address it, the government could press its preferred standard in another case. The court should hold the government to square corners. I welcome the court's questions.
What precisely do you think the standard should be or what the officer should do at the border?
So again, we haven't briefed.
In this instance.
Again, the question of what precisely the standard should be has not been briefed by either side in this case because the government disclaimed putting that at issue. Nonetheless, if you're asking me what I think it should be, I do think it should be clear and convincing evidence and what the officer should do at the border, consistent with what border officers have done for over 100 years, is to check to see whether there is a conviction or whether the returning LPR will admit to the elements of the offense. That is what border officers do every day under 1182, and what they have done, as I said, for over a century, because Congress has said that non-citizens at the border who have committed certain offenses are not admissible.
But in your brief, you talk about Ellis Island and people coming on the ships and how some of these filters were applied by immigration officers at the border then. But it wasn't by clear and convincing evidence, right?
I don't think anybody ever talked about the standard, but I think that what clear and convincing evidence means in this context is, do you have evidence of a conviction?
But the statute doesn't say conviction, it says committed. And what about the one about engaged in criminal conduct overseas? That doesn't say conviction, and Mr. Joshi said it could be like an Interpol alert that caused someone. I mean, I think clear and convincing evidence, if you're going to give effect to these exceptions for LPRs, I think it would contemplate clear and convincing evidence, some sort of adjudication or some sort of a trial where the border officer would have to say what the evidence was.
I don't think it contemplates a mini trial at the border. I think what it contemplates,
hate Congress so much. We're always fighting about their dog
shit,
shit.
A level of confidence by the officer. What information does the officer have before them, and how does that suffice? Does that satisfy the level of confidence required to conclude that this returning LPR, who has a statutory right to return to the country, should nonetheless be stripped of that right, subject to an exception?
Is that only satisfied by conviction?
I'm sorry?
Is that only satisfied? You kind of suggested a moment ago that it would be satisfied only by conviction?
No, I think most commonly it would be satisfied either by a conviction or by an admission to the elements of the offense. Again, here, if you look at
it? Is those two?
I'm sorry?
Are those two it, to follow up on Justice Barrett's question? You said most commonly. I just want to make sure. Is there anything else?
The reason I said that, I think you could imagine a situation where perhaps, which is not presented here, where perhaps somebody returns to the country and there's evidence in their suitcase that they had committed an offense. I don't know, you find their diary in their suitcase or something, and that's what it says. You could imagine a situation like that, but the reason I say most commonly is that I think typically it is going to be either a record of conviction, which officers already have access to in a database, or an admission. And if you look at what happened in this case, if you look at Joint Appendix pages 13 to 18,
yes, but there's some crimes that are deportable
of the officer's
upon
interview
evidence of
of
commission.
Mr. Lau. The whole thing is transcribed in the moment. And what that exchange shows is that the officer identified the pending charge, and from that didn't even conclude that, Mr. Lau was subject to an exception. He concluded that he was actually inadmissible, meaning from the pending charge, he found a conviction. That is not what this statute...
Could he, consistent with the statute, call in witnesses? And say, well, I see you have this, like if you won this case, I'm just trying to game out what might happen. Could he then say, well, I see you have this pending conviction, so I'm just going to detain you here at the border, and we're just going to call in some witnesses to find out about this counterfeiting charge?
As a practical matter, that would obviously take too long, and I don't see any authority in the statute that would allow him to detain, that would allow the officer to detain somebody in Mr. Lau's position at the border.
Well, why not? Because he has to make the decision. So if he has to do it at the border, I mean, we have to give him time to do it. And if what he has to do is gather clear and convincing evidence, that would take some time. It just isn't clear to me that it would benefit LPRs to have a situation in which then you're being detained.
I don't think there is statutory authority to detain in order to decide whether an exception is satisfied, at least not for more than a de minimis administrative sort of period of time when you're actually standing there at the border.
Well, then how can you apply a clear and convincing standard? Because that necessarily assumes some opportunity to pony up evidence, right? Well, you really are just narrowing it down to say conviction only.
2 points, Justice Barrett. One, conviction or admission, and again, as the pages in the Joint Appendix that I cited show, there is an opportunity, in fact a requirement, for the officer to interview the returning LPR. And so there's a conversation, the LPR might admit to the elements of the crime, or again, there might be evidence of the conviction.
So let's say
Second,
the alien, I'm sorry, go ahead.
No. Well, the only other point I was going to make is, to the extent this is a difficult burden for the officer, which I actually don't think it is, that simply reflects Congress's choice that returning LPRs do have a right to return home, and that doesn't leave the government without tools. It can pursue deportation later.
Well, the statute does not say has been convicted, and other related provisions talk about conviction. So assume for the sake of argument that it doesn't require conviction. You say the only other alternative is for the officer, let's say the individual arrives at Newark Airport, and the officer looks in the database and says, I see that you have been indicted in federal court in Los Angeles for, I know this is a state charge, but let's say you're indicted in federal court in Los Angeles for counterfeiting. Do you admit it? And the alien says, no, I don't admit it. Okay, fine, then that's the end of it. That's the scheme you think Congress had adopted?
I think the scheme that Congress has adopted does not allow, as Judge Sullivan recognized, does not allow DHS to parole somebody in order to later determine whether they were subject to parole. Again, going back to the statute.
Well, I think the answer to that is yes. That's the only thing that can happen at the border. Unless there's a conviction and the alien says, okay, or there's a charge and the alien says, okay, I admit it. I admit that I did it. Someone who has a pending criminal charge, unless one of those two circumstances is met, that's the end of it?
Because what the statute contemplates is that the person will be admitted
law says the
unless
admission
an exception
refers
applies.
to stays of adjudication
and the only
where
way that
a judge
parole
accepts
is
a
available
guilty plea
is
and
if an
prefers
exception
taking
applies.
it.
What the government can't do is what it did here, which is to parole somebody in order to determine whether they are eligible for parole. The government can't exercise the very power that it says it needs more facts before it can exercise.
And it's not the end of it insofar as he could be deported, correct?
Correct.
Later.
Correct. The government has other tools, including the deportation authority, after the LPR is admitted and returns home as the
Counsel, can we really say your client was admitted? I mean, whether he was paroled correctly or incorrectly, how do we get from that to he was admitted?
He presented himself at the border for entry into the United States.
Yeah.
The officer let him in. Those are real-world facts on the ground. And now
they paroled him.
The government is now, parole is a legal status. The government is now attaching a legal label to what it is that happened when he was allowed into the country. If the government did not have the authority to parole him.
Right. I understand that there's a question there. I get it. But he was paroled. I mean, that's just a fact on the ground. And I guess I'm kind of curious.
Thank you, sports guy.
Same question to you that I asked the other side is, if that parole decision were so had such negative consequences for your client, was there a means for him to challenge that decision?
I am not aware of one.
Well, you say in your red brief you think there is under 1252A2B on page 34. And I also wonder about 704 of the APA. Just welcome your thoughts.
The path in our red brief there, the 1252 path, the decision whether to admit him or to parole him is something that gets wrapped up into the final order of removal. And so it can be reviewed at the end of the process. But I understood your question, Justice Gorsuch, to be whether, and maybe I misunderstood it, to be whether there was a path to challenge that before it got to a removal hearing. Yeah. And that path I'm not aware of.
How about 704? Or why not 1252 itself?
So 1252 itself talks about a petition. I think 1252A talks about a petition for review from a removal order. Mm-hmm. So again, you need to wait for the removal order.
Okay, you think that's it for that? All right.
Whether 704, look, I go back to my earlier point about all of the issues that have not been briefed in this case.
Yeah. Do you have any thoughts about it?
Theoretically, it might. We'd certainly argue it. They'd certainly oppose it. 704 obviously operates as a catch-all of sorts. Right. I don't know what a court would do with that. Congress didn't leave the status of LPRs to that kind of uncertainty. Okay. And to the extent you believe that the court, to the extent you believe this case turns on that sort of thing, again, this hasn't been briefed, and the more appropriate course would be either to affirm on the very narrow ground that the government has brought this case to the court on, or to dig the case.
Thank you.
Counsel, can you address the consequences of the deferred parole decision? This is from the amicus brief Justice Jackson was referring to before. Mr. Joshi says that from a legal perspective, your client was still an LPR. Those admitted under this circumstance are still LPRs, but the amicus brief says there are practical consequences like job insecurity. Can you address those consequences?
Sure. I think, as Mr. Joshi said, Mr. Lau's green card was taken away. It was replaced with a temporary stamp. These temporary stamps expire after a year. The government didn't even initiate the removal proceedings against Mr. Lau for more than a year. Losing the green card is significant. As the amici explained, employers are hesitant to hire people with only the temporary stamp because they may not be permanent residents for much longer. In an era where ICE agents are conducting enforcement campaigns, a green card is a much more reliable means of identification if you're stopped on the street than a temporary stamp, which can be subject to counterfeiting. And so there are very real practical consequences to this, and it is in itself a form of a loss of liberty. In other areas of the law where we're talking about a loss of liberty, clear and convincing evidence is the appropriate standard to apply. But again, I come back to the point that what is the appropriate level of evidence, the level of confidence at the border, just hasn't been briefed here. Mr. Joshi is acknowledging that there does have to be a determination at the border. He just says this.
Because basically the only thing that they've offered is the border agent should just go on his fee-fees. They haven't offered a standard. They don't fucking have one. This is ridiculous. I'm sorry. I'm ranty today, so I'm gonna let it go.
This entire case now comes down to the level of confidence.
My bad, y'all.
That's again not what has been fleshed out before this court.
Can you address his point? 25% don't show up.
Who fucking cares?
I did hear him say that. Again, the deportation authority, if you initiate deportation proceedings, would also come with detention authority, and so the government has that tool available to it if that becomes a problem.
That seems to suggest that if we rule in your favor, then the government's choice is detain somebody at the border and charge them with removability. And is that acceptable to you?
I don't think it's not acceptable, and I don't think that the government would have that authority under 1226. If someone in Mr. Lau's position is required to be admitted, at that point the inadmissibility 1182 is off the table because he has been admitted. And then the question becomes, do they have a basis to initiate deportation proceedings? First, they would have no incentive to initiate deportation proceedings at that point because all there is a charge. Their incentive is to wait and see whether there's a conviction, and if so, for what offense, and if so, with what sentence. The government has no incentive to use its resources, no good incentive to use its resources in order to detain people, in order to wait and see whether they're convicted. Second, I also don't think that they would have authority to do that. 1226C wouldn't apply because 1226C is, again, about inadmissibility, and inadmissibility is off the table if we win this case and someone in Mr. Lau's position has to be admitted. And I don't think 1226A would apply either because they would simply have no basis for the warrant that 1226A requires when there hasn't been a conviction at that point.
Do you know,
this is an emotional roller coaster. I'm going to need a nap after this shit.
How many LPRs are subject to pending charges? Do you have any idea what that number is? And how many of that would not be defying a court order? Meaning, in my experience, when someone's charged with any kind of meaningful crime in New York, they weren't permitted to travel.
Right. So a couple of points on that. One, at the search stage, the government argued that this was an important case because it affected a lot of cases, a lot of pending cases with returning LPRs. They provided no statistics on that. We don't have those statistics. We tried to call them out on their failure to provide statistics. They didn't come back with any. You would think that the number would be relatively few. In part for the reason that you suggest, Justice Sotomayor. If somebody has committed a very serious crime under state law, presumably the state authorities would prevent that person from what might either detain that person or at a minimum restrict their right to travel out of the country. So the universe of cases in which an LPR is returning to the United States with a pending, relatively minor state offense is probably quite small.
And even so, you could imagine a world like the one that I tried to explore with Mr. Josie, that there are likely a lot of LPRs who leave the country and come back. And I suppose under the government's rule that if we just need suspicion by the Border Patrol officer or some as yet to be determined level of concern, we could have a problem of people just having their green cards removed on the basis of some suspicion that they might have committed a crime of moral turpitude in the opinion of the Border Patrol officer. Is that a legitimate concern?
I think it is a very real risk that if the court rules in favor
I'm going to take a bathroom break, you guys. I'll be right back.
The government that power, that the power may be used for all it's worth. And so you can imagine a situation where border officers, and I'm not suggesting that this is as part of an overarching policy, but where individual border officers do decide to just parole returning LPRs in large numbers. They don't need to satisfy any standard under the government's view other than whatever satisfies the officer. And then that can just continue indefinitely while the government pursues a fishing expedition.
Well, Mr. Turetsky, does your argument depend on our acceptance of this conspiracy theory?
No, it depends on, it's simply the logical consequence of the government's argument that if there is no meaningful check on the ability to parole LPRs, then that power might be used, and it might lead to a situation where, again, LPRs are paroled just based on a mere suspicion, as your own hypothetical suggested to Mr. Joshi early on in the argument. You look kind of fishy to me. That can then go on for a long time.
Yeah, but that's not what we have here. We have a criminal charge. And the immigration officer didn't make that up. The charge was leveled by the state of New Jersey. I guess the state of New Jersey is in on this conspiracy.
Again, I don't think it's a conspiracy, but what I do think is that the charge does not show that the person has actually committed the offense. There's still a presumption of innocence at that point, and the charge doesn't show that he's committed the offense.
Well, it doesn't say, 5 doesn't say was convicted. How about Romanet 3, has engaged in illegal activity after having departed the United States? Same rule there?
I think it would be the same rule. The question is there some evidence before the officer, or does the LPR admit to something in an interview? Again, people do admit to things in interviews that perhaps they shouldn't, and that's how that would be applied. But again,
I'm sorry, go ahead.
No, please.
An LPR leaves the United States, goes to France, flies back to the United States. While the plane is in the air, the federal government receives an urgent message from the French police. He shot somebody while he was here, just before he got on the plane. But he hasn't been convicted, and in that instance, he hasn't even been charged. Would that person fall within Romanet 3, has engaged in illegal activity after having departed the United States?
I don't think so. I think in that situation, we don't know that. But again, all of this goes to the question of what is the level of proof required at the border. That question has not been briefed. These are complicated questions that are not directly answered by the statute. They involve background principles. They might involve policy considerations. None of that has been briefed. And in fact, the government expressly disclaimed that in the cert briefing and didn't present it to the Second Circuit either.
Did I understand your answer to Justice Alito's question was no, he could not be detained?
If all we have is...
All you have is a phone call from the French police saying we think he just shot somebody. He comes to the border, and the officer at the border cannot detain him?
I think that would be no more than the equivalent of a charge, which doesn't prove that he actually engaged in the conduct. But again, whether or not that would be sufficient, I think the point is there is some burden at the border to show that one of these exceptions is satisfied.
I know your general rule. It just seems to me to be pretty bizarre to say that in that situation they couldn't even be detained.
Again, perhaps he could be detained in that situation.
Yeah, I'm pretty sure this is Roberts.
My point is, none of this has been fleshed out. These are questions that the government actually
they
disclaimed.
could say, look, all I have is a call from the police in France that you just killed somebody. We need to flesh that out a little bit?
Look, what it might be is probable cause for a non-immigration arrest in that situation. You could imagine that it satisfies probable cause. But whether probable cause is enough to show that one of these exceptions applies, it doesn't show that the person, a tip does not show that the person has actually committed an offense.
It's not a tip. It's a call from a French police official.
So if it's a call from French police officials, you could take that as a basis, I would think, for wholly apart from the immigration laws, for arresting the person and potentially extraditing them to France on that basis. That, I think, is a different question than what's presented by this case or by these exceptions here.
Can I ask you a question about I'm sorry, Mr. Chief Justice.
No, I'm done.
Okay. About the burden of proof, I thought your argument depended on it being clear and convincing evidence. Why would you say that hasn't been briefed? I might not be following. I mean, I know that Mr. Joshi is saying, well, for parole, there's a satisfied standard, and then we defer the admissibility determination, and that is by clear and convincing proof in the context of the removal proceeding. But I thought that you did have a position that it's clear and convincing at the border.
So what our argument depends on, because of the way in which this case has been teed up from the Second Circuit on, is that there is a determination that has to be made at the border. Mm-hmm. The government's position in the Second Circuit was
to knock off the
we have no burden at the
It's
border.
not
Our
giving
only burden is in the
confident.
ultimate removal hearing. So our position, again, the way this has been teed up is, yes, you do have a determination, an obligation to make a determination at the border. Now, the government has never challenged, never disputed, that if a standard, or until the till the end of this case, has not disputed that if a burden applies on it at the border, that burden is clear and convincing evidence. Now, if we were to brief and argue...
I don't really understand Mr. Joshi to have said this, and he might be right or he might be wrong, but as I understand it, he says there is a burden at the border, or maybe he says this was like part of his 1, 2, 3 answer. One is that there's really no burden at the border.
I don't think that there's necessarily
but 2 was there's
burden.
like
it's more
a reasonably
the
satisfied
Border
burden
Patrol's
at the border.
fees.
That is what he says today. The point is that 2 and 3 in his 3-part answer are new as of today and the merits reply.
And why is that? Maybe I haven't focused enough on this, but when I'm staring at the QP in the first brief, and it says whether to remove is inadmissible in LPR, blah, 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 whether to remove that person, the government must prove that it possessed clear and convincing evidence that the alien committed the offense at the time of his reentry. So why doesn't that set up the question that you're saying was not involved?
I take your point about the question presented, Justice Kagan. That's precisely why in the bio we said, wait a minute, it looks like your argument might depend on the court deciding not only whether there is a burden at the border, but what that burden is. And this case would be a poor vehicle for it because you didn't raise that issue of what the burden would be in the Second Circuit. Cert reply page 11, what they then came back with and said is, quote, to confirm, the government is not challenging the clear and convincing standard. This question is about when the government must carry that burden. Because the Second Circuit created a circuit conflict and disrupted immigration enforcement, disrupted immigration enforcement by incorrectly requiring the government to carry that burden at the border, this court's review is warranted. The whole case was teed up on the assumption that if a standard applies at the burden, it's clear and convincing. But their argument was there is no burden at the border at all.
But that's because they thought that they could parole at the border. I think if we accept your argument that the admissibility determination has to be made at the border, then it necessarily means that the clear and convincing standard applies as the government has teed up this case. I agree. For purposes of this case, they said, as for the admissibility determination, clear and convincing is the standard. But if you win, it's necessarily saying that the clear and convincing determination applies at the border. I might not be tracking.
I don't think that's quite right, Justice Barrett. If we win, all the court needs to hold is that, contrary to the government's initial argument and arguments to the Second Circuit, Judge Sullivan was correct that there is a burden at the border. The government does need to show that as of that time at the border, the returning LPR was subject to one of the exceptions.
So the government can parole. You're conceding then that the government can parole in Mr. Joshi's kind of 1, 2, 3 formulation, but he can parole the officer, can do so at the border, but you're just saying, well, maybe it's not clear and convincing?
No, he can parole at the border. Mm-hmm. Our argument would be, again, if it were briefed or in a future case, our argument would be that the correct standard is clear and convincing evidence. But the government would be free to argue that it's something less. The government would at that point be free to argue, and the BIA could have the first crack at this.
They just can't tell you what that
less
is.
Okay, we accept the court's holding that there is a burden at the border. We think that's less than clear and convincing.
I am so confused, though. I thought that your argument was that they had to make the determination whether one of the exceptions applied at the border, which goes to whether they were seeking admission, and that standard was clear and convincing. And if they have to make the admissibility, like whether one of these exceptions applies, so whether the LPR counts as someone seeking admission or not, why wouldn't, if that determination has to be made at the border, why wouldn't the clear and convincing standard apply in your theory of the case?
Again, I think it would. Under Mr. Joshi's theory of the case, they seem to now be acknowledging that there is a determination that has to be made at the border, but he says perhaps that standard is just determination to the satisfaction of the officer. Or maybe it's the Third Circuit standard at most, determination supported by probable cause. The question of what standard should apply at the border is something that the BIA could explore in another case, the lower courts could explore in the first instance, but it's not something that has been briefed or fleshed out here other than in today's argument and in passing in the reply brief.
And that's because, Mr. Tversky, I'm just trying to make sure I understand as well. I was with Justice Barrett a little confused. So it's because the government's initial argument was that we don't have to have the border agent determining whether or not the person is in any of those buckets. They can just parole the person in.
Correct.
That was their original thing. You don't have to, and now the government is saying we admit that the person has to be seeking admission and therefore one of these 5 have to apply. But now they're arguing the standard for determining whether or not one of those applies is something less than clear and convincing.
Right. Their argument was parole first, figure out whether parole was proper later. Judge Sullivan for the Second Circuit correctly rejected that argument because that is not the sequence that the INA contemplates.
And you understand them to today be agreeing that that's not the sequence. We need to have some determination made, and now the dispute is over what level of proof is necessary.
Correct.
To make that determination.
They just think here today and in passing in the reply brief that standard of proof is just to the officer's satisfaction, or maybe it's probable cause. We would say it's clear and convincing evidence. None of that has been briefed or developed. Those should be issues for another case after this court either affirms on the narrow timing question or digs. And look, I'm not going to be the lawyer who stands here and tells you what the court will or won't do in an April argument. But I think this would be an appropriate case in which to dig rather
yesterday.
An appropriate case in which to dig rather than take on these questions.
Just to be clear, we will take appropriate action without regard to the calendar. Justice Thomas, Justice Alito.
I am a bit baffled by what you're saying about what question is before us.
Alito probably finds vaginas baffling. Let's be so real.
The question presented says, question is whether the government must prove that it possessed clear and convincing evidence of the offense at the time of the LPR's last re-entry into the United States. And the passage that you read from
how many more times can we go over this? The government has them presented shit on its lower level.
Just says the government is not challenging the clear and convincing standard. The case is about when the government must carry that burden. So I interpreted that to mean they admit, at least for the purposes of this case, that clear and convincing is the standard at the removal proceeding. But the question of what is the standard at the time when the alien is trying to come back into the United States is something different.
I think it is something different, but as I read page 11, I think what that is saying is the case is about when the government must carry the clear and convincing evidence standard. It's not about whether there is some other burden or standard that the government could conceivably have to satisfy instead. It's do we carry clear and convincing evidence at time 1, or do we carry clear and convincing evidence at time 2? That's the premise on which the government brought this case to the court.
Yeah, and you're saying they have to do it at time 1.
We're saying that it has to be at time 1 because they haven't disputed that if there is a burden, that is the burden. If they want to dispute that, they are free to do so in another case where they present that to the lower courts, perhaps with BIA guidance to go on.
Okay, thank you.
Justice Sotomayor?
That's the point, which is they've never said to us except here, this is our burden at the border.
Correct.
Thank you.
And in brief passing in the reply brief for the first time.
They've suggested there's no burden at the border, essentially.
Right.
Unrevealable burden.
That's right, Justice Sotomayor.
Justice Kagan? Justice Gorsuch?
Briefly, I had thought the case, maybe you can correct me, but I thought the case was about whether the government could satisfy its burden in a removal proceeding by clear and convincing evidence showing at that time the facts without regard to what happened in a separate
not wrong. This shit was all over the place
at the border.
I wouldn't think of it as a separate parole proceeding at the border. I think what the case is about is
it's a removal proceeding, right? That's what's before us. And the question is, does the government have to prove its burden with respect to whether the immigrant committed the crime?
They haven't even, they're challenging that there's no burden to meet.
Right.
But Justice Gorsuch, the only way that we ever got to that removal proceeding
I understand
was
because there was a parole proceeding that preceded it. I understand that. Yeah. Okay, thank you.
Justice Kavanaugh? Justice Barrett? Justice Jackson? Thank you, counsel.
Thank you.
Rebuttal? Mr. Joshi?
Thank you, Mr. Chief Justice. Just 4 quick points. First, on respondent's new request for a dig. I think we've had the QP read aloud a couple of times. We clearly were challenging the requirement that there be a clear and convincing evidentiary requirement at the border. The Second Circuit said yes. We say no. That's all you need to say. That's fairly encompassed in the question presented. As my response to Justice Jackson said, we don't think there is any evidentiary requirement
These
at the
attorneys
border.
are
We
sassy
think
this
that
morning.
the government can satisfy its burden, as Justice Gorsuch just said, in the removal proceeding by proving that the respondent was in fact seeking an admission at the time. My friend says that our original position was that we can, parole someone to defer a decision on whether parole is possible, and we've only recently switched tracks. We have never said that. He has not quoted a single line from any brief below or here in which we said that. And in fact, I'll just, sorry to do this, read to you from our opening brief in this court on page 32. Observing that the INA authorizes the Secretary to parole any alien applying for admission, respondent has argued that, quote, the government must determine whether an LPR is treated as an applicant for admission before the non-citizen is paroled into the country. True enough. We never disputed that. We just said that obligation in no way implies that in subsequent removal proceedings, the government must prove that it made the correct determination by offering only the evidence that it had in hand at that prior time. That's what the Second Circuit held. That holding is clearly wrong, and the circuit split it created is intolerable right now. I mean, JFK is in one circuit, Newark is in another, Houston International is in a third. Each of these three circuits has a different rule, and it's going to be incredibly hard to manage if you dig this case and if you affirm all of the consequences that Justice Barrett and others have been discussing are going to hold. We're basically going to find that the seeking admission clause is unenforceable at the border. That leads me to my second point, which is Mr. Dvoretsky basically said you're going to need a conviction or just an admission of guilt. I don't see how that's consistent with the INA's text that says committed an offense. It's certainly not consistent with Romanet 3 about criminal activity abroad. It's not even consistent with offenses identified in 1182A2 because most of them, as I said, don't require a conviction to be inadmissible. The human trafficking, the drug trafficking, the prostitution, some of the other ones. So you're going to need a conviction just to determine whether you've committed an offense, but then you don't need the conviction to render you inadmissible. That's completely topsy-turvy. That can't possibly be what Congress wanted. And that's to say nothing, as I said, of the other 5 clauses. If it's clear and convincing, even something as straightforward as Romanet 2, I think, is if you've been absent for 180 days from the country. And suppose a border officer says, well, I see your passport stamp and your round-trip ticket was 200 days ago, so you've been absent for 180 days. And the LPR says, oh, no, I haven't, although that's my round-trip ticket. In the interim, I've been driving back and forth into this country several times, so I don't have 180 days of absence. Does the officer have clear and convincing evidence that the LPR is not telling the truth?
Oh, my God.
I can't imagine that he does. But that's exactly the sort of thing where the officer might say, all right, I'm going to parole you, and we're going to figure this out. In 30 days, show up and show me that you've been driving back and forth across the border where we don't.
Because Border Patrol doesn't have access to immigration
if necessary,
documents.
We'll go to removal proceedings, and then the IJ will decide on the stand whether he's credible or not. Under respondent's view, even if that LPR were not telling the truth, too bad, because the border officer in the moment didn't have clear and convincing evidence of this untruthful assertion. That, again, cannot possibly be right. Finally, in terms of the statement that my friend made that there's just no meaningful check on the ability to parole LPRs. As I said, number one, there is the presumption of regularity, and you would really have to have a DHS-wide conspiracy for the parade of horribles that respondent talks about to materialize. It is telling that our rule has been the background rule for decades, if not over a century. It certainly has expressly been the rule in this circumstance in the Fifth Circuit for more than a decade. You haven't seen these consequences. The Third Circuit since 2011, probable cause, but still much lower than clear and convincing. You haven't seen these circumstances. So I just don't think it's reasonable to say that. Congress provided that parole decisions are unreviewable. It made a judgment that they're unreviewable. And I know that's always going to cause some heartburn and difficulty when you say something's unreviewable, but unless you think all of DHS
This whole
is
thing is
composed of,
giving me heartburn.
to use a
It's
phrase,
making my
monsters
ass
or
itch.
idiots, that's just the system that Congress enacted.
Thank you, counsel. The case is submitted.
I think everybody knows how I feel about that dog shit take. Law, please go ahead, Pookie.
There's so much there. Yeah, they're fundamentally wrong on several aspects of it. So, in this case, I thought Jackson hit on, hey, you've got the presumption that this LPR, this licensed permanent resident, is not seeking admission to the United States. If you're seeking admission, if you're a citizen and you travel back out, to a foreign country, and then when you return to the United States, you're not seeking admission to the United States. You're coming home. And that's what happens with licensed permanent residents. You're not, under the terms of the INA, seeking admission. You're coming home. And so that's the baseline that needs to be set. Now, what's happened here is a border agent said, well, hey, you've got this pending charge against you, so I'm not going to let you come back home. I'm going to parole you, which is give you temporary status, and then take your green card away and give you a stamp that lets you stay here for a year, and then we'll see what happens. And so that's the fundamental issue here. And now the question that's being presented is, what's that threshold that needs to be met in order to deny a licensed permanent residents their right to return home when there hasn't been a conviction? And what the government's arguing is, well, it's kind of a moving target now, is clear and convincing evidence, which is above probable cause, or above a preponderance of the evidence, but below clear and convincing evidence. Below beyond a reasonable doubt that this person did in fact commit the offense. But the crimes of deportability are very clearly spelled out in 1226, 1227, and there's different levels. If there's evidence that you committed a crime, sometimes that's deportability, a crime of deportability. So trafficking, for example, unaliving, you don't actually need a conviction if there's evidence that you did in fact commit the crime. Might seem like bullshit, but that's just the way that it was written. But then there's crimes involving moral turpitude, which is CIMTs, and those you actually need an admission of guilt or a conviction. Now, the reason why it says admission of guilt is because there are certain diversions that happen that result in you admitting guilt, but the judge not actually convicting you. So a lot of times if somebody's being charged with a crime as part of a plea deal, they'll admit to that crime, they'll admit to the offense, but then the judge doesn't actually accept the admission. And those are things like stays of adjudication or deferred adjudication. Every state jurisdiction has its own label for it.
My sister did pretrial diversion when she got smug charges, and basically it's there, but it's not there, and the whole thing.
Yeah, so pretrial diversion's a little bit different because you're not even actually. I guess it depends on the state. I don't know if she actually did an admission of guilt, or if they just said, "Hey, we're going to pause prosecuting you, give you a chance to do these deferred actions. If you do this, we'll dismiss the case." So sometimes, in Minnesota, we call that a continuance for dismissal. Where, hey, we're going to pause everything and then give you a chance to make up for whatever we're saying you did wrong. A stay of adjudication is a little bit different, where you actually do admit guilt, but then they're not going to accept that. But for immigration purposes, that mere admission of guilt is enough to deport you for a crime involving moral turpitude, even though you didn't actually. The judge never convicted you of that crime, if that makes sense. So in this instance, what the respondents are saying is, hey, they need to have clear and convincing evidence that you did the offense, in order to revoke you, and that's not present here. And the government seems to have come back and said, whoa, that's not the right standard. And then they're trying to make two arguments at once, which conflict with each other. One is they're saying, well, hey, this was always the thing. You need to say yes, it's clear and convincing evidence, or it's nothing at all, which I think is going to be a difficult line to draw, because now because of the lower court's conflicting rulings of this, you got the Fifth Circuit saying, hey, they could do it whenever they want. You've got the Second Circuit saying it's got to be clear and convincing evidence. You've got the Third Circuit saying it needs to be a preponderance of the evidence. So the court really has to either say, yes, it's clear and convincing evidence, or nothing at all. But then the respondents gave another option, is say, hey, they didn't brief this argument that they're making it today, so you should dismiss the case as improperly granted, which is a dig, which you heard a couple of times. Say, come back again and make your arguments more clear.
Yeah, so like I will just say this. First of all, I am planning a RJ meetup in Cozumel. Apparently, I need to get I am an American citizen tattooed on my ass or something. I want to be able to come back. Sorry. And then the second one would be like, I'm upset that like the only bar that the government has delivered is, well, if the border agent feels comfy, good in their heart and their feelings about this person. That's not a fucking standard. That never has been a standard. Like, how can you just be like, nah, if the border agent's cool with it, we're cool with it? Like that doesn't make a lot of sense. And that creates a lot of inconsistency in admissions. I don't know. That's like fundamentally bugging me here. The court's going to have to do it, or like, but they don't want to. And you can tell they don't want to, which is why I don't know which way this case is going to go. In fact, I'm leaning 5-4 or 6-3 that they're just going to let them continue with their dog shit because they don't want to make a decision and Congress is fucking incompetent. I said what I said. Normally, I'm not for that, but this is one where there's too much bullshit going on.
Well, yeah, because there's like three different ways that this can go. I can't even call it, because it depends on how they're going to go. If they're going to dig it, if they're going to affirm, deny, or do something in between. There's four different ways that this can go, and there's so many. Part of what frustrates me too is the justice's ignorance on immigration laws coming forward and the government's ignorance on it. Like they're talking and even the advocates, they're talking about admissions as if it's like they admitted it in an interview, and that's not what the law requires. That's not what what 1226 and 1227 requires. It's a judicial an admission to the court that you committed the crime. That's what admission means, and that's what it's always meant. And I'm a little bit. I don't know how much immigration. I know she did public defense work, but how much immigration nexus that KBJ had, or maybe if she did, it could have been before IRA in '94, where a lot of this changed. But there is. The way that they were using admission is not how it's written into the statute or it's been applied. So maybe they'll go back. Maybe their law clerks will do a little bit of briefing for them when they're trying to come up with their opinions that are circulating. But that really caught me off guard.
I'm telling you right now, it would be worth it for me to go to law school just so I could be a law clerk. I'm not saying I would get on the Supreme Court, just for anybody, because I swear to God, I don't know what these judges are doing, but sometimes I hear them and I'm genuinely fucking embarrassed, like genuinely. And like, I normally love it, but it's just so frustrating to me right now. And I don't like that we don't have a standard. Like, I don't feel like it's unreasonable to say, like, Border Patrol needs something, whether it's, probable cause, reasonable suspicion, whatever it may be, to do these. I don't feel like that's unreasonable. Like, am I crazy? Maybe, I don't know.
Well, in the government's position that parole decisions are non-reviewable. So you have a border patrol agent, which, by the way, are the same people who couldn't coordinate the detention of a suspect and ended up shooting him in the back 9 times. Border patrol agents who have 2 years of college and 0 training on criminal procedure, on the rules of evidence, and particularly if the charges are in a different state court, they have no idea what's going on there, and they just get to put their lick their finger and put it up in the air and be like, nah, you're going to be paroled in. And by the way, this decision is unreviewable. That just is just a fundamental due process and equal protection issue when you have people who can't figure out that shooting an unarmed person in the back 9 times isn't something that's wrong, being able to make these decisions.
That's crazy talk, Law. Of course they can make those. What are you talking about? It's like the same as being a prosecutor, just something lower, Law, something lower, I mean, whatever it may be. That's going to be my new answer for you. You're going to ask me to do something, and I'm like, something lower, like just something lower.
And I could be sold on, because parole is an executive privilege. I could be sold on something that's like objectively metric, not being reviewable. Like, hey, if this, then that. And it's like, if you're convicted of this, then we have to parole you. And that's not reviewable because it's just an objective fact. But here we have the government arguing something lower. And then, by the way, it's not reviewable. That is just opening the door for subjective application of the law without any sort of recompense. And I understand.
Exactly.
Well, I think that some of the judges, ACB for example, were kind of hung up like, well, hey, if we say that this isn't allowed, then they can just detain them under removal proceedings. It doesn't that make things worse for your client? And I'm glad that the advocate, I don't know who it was, said, yeah, it could, but there's other avenues for relief there. Because that's the legally consistent position. Is well, their judges are trying to box them into, well, hey, if we actually grant this relief, then the government could just go around detaining these people instead of paroling them. And I like that he said, yep, that's what would happen, because then we have other avenues. We could do a habeas petition that says, hey, what's your grounds for holding this person without without bond or release? And then they have to justify that. That's relief that goes before an IJ in order to, or not an IJ, a federal district judge, to say that, hey, they do have some reasonable grounds to hold this person. It's not ideal. I mean, it's not the best circumstance. Clearly, somebody who would rather, who's going to be paroled, would rather be paroled than detained. But on the other hand, somebody who's got a right to return, a licensed permanent resident, would rather just go fucking home than be paroled and have their green card taken away.
Look, here's where I'm at. I don't think anything is acceptable out of this other than, like, to your point, it's an if this, then that. You know what I mean? Like, I would be willing for that to be the case. Like, this guy committed some sort of fraud or whatever. Like, if you have X, you're going to be paroled instead of X, Y. Like, I'm fine with that. The point to me is that there's no standard and they're gonna have to set one. If I hear them say one more fucking time, we're just gonna, Congress needs to set a standard, blah, 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 blah. I'm going to lose my mind, and it's not because I want the justices legislating from the bench. It's because Congress is not doing anything, and I don't like instability in our systems. Like, I cannot see a life where I want our system to vary based on how good a day a border agent had. I mean, that just seems ridiculous to me.
Yep. Yeah, it's entirely too subjective, and yeah, I need to read some of the amicus that were referenced in there, because these are going to be people who are actually experts in these areas of the law, who are going to be trying to supplement some of the information that maybe the advocates didn't hit on.
Well, and so this was a genuinely confusing case because the government files, and then you have the reply brief, and then there's like a bunch of back and forth, and then you have the amicus, and like even the judges were confused about like some of the arguments that were being made, because honestly I didn't know which way or where this case was going to go, because it was ridiculous. It was a lot of like back and forth, and I was like, I don't know what they're going to do with this shit, so I'm just going to sit here and I'm going to listen, and we'll roll with it. Like, that's how I was with this one. But the fact that we don't need to have a standard is very disturbing, that the government is arguing that. Like, we don't need to have some sort of threshold. Like, I'll even accept if the Supreme Court were to come back and be like, all they need is just reasonable suspicion. All they need is just probable cause. Something. I'll take anything. But don't leave it just open to whatever this one guard decides. Like, I know I've had bad days before. Freaking like, I've texted Law on bad days, and he's like, what the fuck? And I'm like, I'm sorry, I'm just having a bad, like, I don't want things to be open to whatever kind of day this person is having, whatever their subjective feelings are, or if this person looks bad to them, like they're going to have a whole different outcome than a person who looks trustworthy. That just seems ridiculous.
Well, and I did like that the justice, I forget which justice pushed that question, but it was like, well, if they look bad, and then the answer was, well, we've got to trust our border patrol agents and trust DHS to be doing their job. And there's no reason to think that there's going to be some broad sweeping issues. It's like, bitch, have you been paying attention?
No, that fucking part. Like, I had a whole rant prepared for that, and I think it was Sotomayor. I want to say it was Sotomayor, but they're like, yeah, we just need to, have trust in the system, because there would have to be a whole conspiracy. And I'm like, I feel like there really fucking is. And I feel like even the administration has told you they want to deport, what was it again? Everybody. So what the fuck?
Cass, it's not like that we've had horrible misstatements made by DHS regarding immigration. It's not like that they've been propping up false numbers put out by far right-wing white nationalist groups disguised as independent immigration councils. It's not like they just indicted the Southern Poverty Law Center for going after these particular groups.
We didn't talk about that last night or anything at all.
It's not like the secretary of DHS had to resign, or had to get fired and assigned to the Avengers squad in order to save face. Like,
Shield of the
Americas. How dare we impugn the integrity of the Department of Homeland Security?
It's not like we watched, what was it, 5 or 6 border agents unalive an American citizen. I was in town for that, Law. Like, I was there. Like, it's not like I had to go watch you do 300 interviews about it. Like,
17 of them at a gun range? No.
Yes. Was it at a gun range, though? That's the bigger question. Oh my God, I saw a video that got posted by an organization. I'll say it like that. It's one that you know. And all I wanted to put on there was it at a gun range? But I was like, nobody will understand that joke. Okay. Anyway, I'm going to let that go. How do you think they will? I have genuinely no idea, Kelly. Genuinely, this one, I cannot call it. I think personally, this is just my speculation, it's going to be 5-4, 6-3 in favor of the government on this. That's my guess.
Yeah, I just have I can't pinpoint what the field is. I can identify 4 different ways that this could go, and I can think of, different justices that would go in each of those buckets. I can't even begin to predict this, but I don't see the status quo staying. That's the best that I can say.
Well, to me, it's the way that they frame the questions with both parties. And then it was that Roberts was fairly aggressive with the respondent. Genuinely, like, I'm just judging. I'm going on vibes. I'm voting on vibes, okay? The way that they frame the questions, I mean, Thomas, Alito, Gorsuch, I think those are my autos. Like, I feel like they were just like not digging the respondent's argument here. But Kavanaugh had pushed back for the respondent. Coney Barrett a little bit more kind of, I could see her going either way. And then I felt like Roberts had a lot of pushback, which is why I think this may be a 5-4 or a 6-3 in favor of the government. Not that I think they should be in favor of the government, but because of their typical dog shit and not wanting to actually take a stance on anything. And like, listen, there's a time and place for textualism, originalism. You're never going to get me arguing that. But sometimes there is a place for consequentialism, and they don't give a fuck. They're unbothered by that shit. So that's where I'm at.
No, yeah, I don't think that's a crazy take. I'm struggling to see, because there seems to be so much discrepancy about what the issue was and what was briefed, that they might just dig it, dismiss it as improperly granted. And I think they might have 4 or 5 votes for that, maybe 6, just because of the confusion of the question presented. But then, if it's supporting the government's position, that just means that they go back to the current state. So I think that, that's, I mean, the pre-additional burdens of evidence being added. So I think that would probably be the next strongest position.
Like, I'll accept a dig. Like, if they can do that, like, I'll leave that alone. But like, for some, just, I don't know. Again, this is my vibe. This is my vibe that I'm getting, is that they're gonna be like, yeah, no, border agents, they don't have to give a shit. They can just rock it on with their fifis because the text doesn't say X, Y, or Z. Yeah, no, this question was ridiculous. Like, even when I was reading it, I was like, what's going on? And like I said, I read, the cert, and then I read the reply, and then I read 1 or 2 of the reply briefs, like the back and forth, and then I read like 2 of the and I was still like, I don't know what the fuck they're actually trying to answer here. So to be honest, I could see why maybe the justices were confused, but I was kind of hoping they were smarter than me. So that may have just been where we're at.
I would feel a little bit better if I didn't hear several like glaring issues with how the actual immigration law applies, and generally, like, you'll hear those in oral arguments sometimes, but they'll never actually surface in the opinions. The things that I heard that I was like, well, shit, that's not right. And we put these justices and these advocates on a pedestal, but they're not experts in every area of the law. They're not, when we're dealing with constitutional questions, a lot of them are very well informed in that. When you're dealing with like the nuances of applications of particular statutes, they're not going to be experts. But their clerks are fucking nerd geniuses that will sniff all this stuff out. So there is some corrective action. And I know I have friends who have clerked on the Supreme Court before, who have had to come in and say things, like, one of the more difficult discussions you'll have to have is that, hey, Justice, you said this, and this isn't exactly correct during oral arguments, or, the justices will ask something to be included in a brief, and they'll have to be like, well, I don't think the law, the case law actually supports that. So a lot of times, especially with these justices, most of them come from corporate law, white shoe law. They're not, they're not people who have had a tremendous amount of experience in criminal law, and I don't think any of them have any experience in immigration law, like, beyond just ancillary, maybe your client happened to be an immigrant type things.
Yeah, I just like, can I be your clerk law? Because I could sit there and read books. Like, I'm here for that shit. That's amazing.
Yeah, I would never get appointed to judgeship. Maybe if I ran for it, I could run a hell of a campaign, but like, I don't know why I'd want to do that.
Damn it, law. I need you to be a Supreme Court judge, please. Okay. No, we actually do have a Fourth Amendment question coming up next week, though, which I'm excited about. There's a geofence warrant, and they're asking if it violated the Fourth Amendment, and should the exclusionary rule of evidence, or should the exclusionary rule apply to evidence obtained? I'm fascinated by this because geofence warrants are fucking weird, and I want them to go into lots of details on this. But anyway, I'm sorry. Back to the case we're actually talking about. I don't know why you were bringing that up, and it made me think of that. But yes, this question was confusing as hell. The fact that we don't have a standard is absolutely ridiculous. And I hope that the judges don't do what I'm vibing that they're going to do. And it's just like, yeah, no, border control agents can just have all the fifis and, run wild. But, I don't know why I'm stuck on it. I just have the feeling that this is the way it's going to go. And what they're going to argue is that the text only says blah, 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 like they're going to do that dog shit. And I'm going to be like,
could you read the question presented one more time?
Absolutely. It's kind of long, so bear with me. Under 8 USC 1182A, various categories of aliens, including those who have been committed including those who have committed or been convicted of certain crimes, are ineligible to be admitted to the United States and subject to removal. 8 USC 1182A2, and then there's several references here. Let's see. Under 8 USC 1101 A13C, a lawful permanent resident who is returning to the United States after a trip abroad is generally not regarded as seeking admission into the United States and is therefore not typically subject to inadmissibility grounds in Section 1182A. But that general rule does not apply to an LPR who has committed an offense identified in Section 1182A2, i.e., an offense that would render him inadmissible. The question presented is whether to remove an LPR who committed an offense listed in Section 1182A2 and was subsequently paroled into the United States, the government must prove that it possessed clear and convincing evidence of the offense at the time of the LPR's last reentry into the United States. A mouthful.
Yeah, Jesus. Yeah, I mean, that question is so complicated by two things that I can point to. Is the crime that he was accused of is not a rendering for inadmissibility until a conviction or...
I'm listening to you. I'm going to grab water real quick.
Yep. Until a conviction or an admission of guilt before the court. So as applied to him, that position wouldn't work. But what we have is a circuit split between the lower courts, which essentially has to be resolved. Or they have to say, come back with a better argument, and then, they'll take up another case with that. So, yeah, I don't see the respondents winning. It's just how it gets narrowed. If it's digged, if it's just denied, and then we go back to the status quo, which is a circuit split, which the courts generally don't like to do, or if the courts are going to create some sort of a test, a standard, which they generally don't like to do unless it's a clear and universally applicable test, which it wouldn't be here.
I don't know why they can't just be like, you need reasonable suspicion, right? Like, why can't they just create some form, some sort of standard? Because it's insane to think that in X area you have to use this, in B area you have to use this. Like, it doesn't make any sense, and it makes the system incompatible. Like, are people going to start flying to the Second Circuit, because they know that X, Y, or Z won't have, like, it's not a good thing. I don't like this. I don't like inconsistencies in the system. I feel like whether you're an immigrant or not, the system should kind of be the same for everybody, same opportunities,
Yeah, I definitely don't see them winning on the question presented, but the respondents still win if it gets digged, and the respondents still win if the court says that you can't apply 1182 to a licensed permanent resident unless there's a conviction or an admission of guilt before the court. So they still win even though they lose the question presented. This is just such a weird. There's like 10 spinning plates, and we have to just see which is the last one standing.
Yeah, that's kind of what I'm trying to figure out. Is, like I said, this question is just, it's all over the place. And like I said, like, that's why I like went through and read as much as I did, or at least tried to, because they're long and I only have so many hours in a day. But like, I went through and read as much as I did, and I genuinely felt more confused after reading it instead of less confused. And I was like,
well, and compounded by the fact that the oral arguments were diverting from the positions in the brief. So.
Yeah, well, it was going to ask your opinion on the Kash Patel lawsuit. I know is he suing someone? I heard about it, but I haven't paid attention.
Yeah, he sued for defamation. I think it was just dismissed. I just saw the headline. I didn't read it because I don't give a fuck about Kash Patel.
I love that. He's such a douchebag. Like, I can't. What's your question?
I wasn't trying to take away. I was just gonna ask you, as someone who is a legal expert, what do you think?
I'm not a legal expert. He's a legal expert. I just work here.
I was just trying to get someone who has some legal knowledge. Like, what are the chances of him actually like getting anywhere with this lawsuit due to the fact that the defamation case would be is. I don't know how. I'm trying to think of how I want to word this. It's actually not sound stupid. Defamation is it's a weird case.
Defamation is very difficult to prove in court. I can tell you that much. It's not as easy as people run around on the TikTok streets screaming, "You defame me!" Every 5 minutes. Say it's not exactly easy to prove, and
that was a good impression.
Sorry, my bad. Listen, it's every 5 minutes I hear, "I'm going to sue you for defamation." Bitch, you don't have any financial loss. No, the fuck you aren't. Like, no, you aren't. Sorry. I'm ranting. Go ahead, Law.
Yeah, so Kash Patel is a public figure. And public figures, in order to survive on a defamation case, you have to prove one of two things. One is that the statement was made when it was known to be false with the intention to cause harm. So it's called actual malice. So I know it's false, and I'm putting it out there with the intent to cause harm to this person and their reputation. Or you have to know that it's false, and you know that putting it out there will have you're recklessly disregarding the impact that it's going to have on somebody. And here, I think the statement was made is that Kash Patel spends more time in nightclubs than he does at the FBI headquarters, and that's hyperbole. That is just a rhetorical statement. It is not something that's defamatory. Now, if they had said Kash Patel spent 432 days of the last 2 years at nightclubs and only 312 days at the FBI headquarters, that's a that's a statement that you're asserting to be true, that you know it to be false. That's different than just a rhetorical hyperbole. He also sued the Atlantic for $250 million because they reported those claims of excess drinking and things like that. That lawsuit's going to get tossed too, because he provided no evidence that those statements were knowingly false. He just said that they have no evidence that it's true, and Atlantic pointed to undisclosed sources, which they're allowed to do. So they're saying that, hey, here's what is being told to us by people who are asserting knowledge of the incident. So again, both of these lawsuits are garbage, and it's just a waste of time.
Did they not see the Afro Man suit? That was a classic case of like, how far can hyperbole go? Afro, like lemon pound cake, bitches, like, I'm just saying, this is ridiculous. I didn't even know, like, I can't keep up with Cash Patel and the Atlantic shenanigans. I feel like every time I open something up every other month, either the Atlantic, Cash Patel, or somebody from the Trump administration is whining about some bullshit. I cannot do it. Listen, I'm going to say it like this. If you don't like people talking about you, don't become a public figure. I said what the fuck I said. I know that's probably harsh and mean, but I just don't give a fuck anymore. You don't want people talking about you? Don't be a public figure. That's just the way it works. Sorry.
Yeah, it's the cost of entering in the public sphere, and you can be a traditional public figure. So the any politician, and the higher you are as a politician, the less likely a claim of defamation is going to succeed. The more prominent you are in the public, the more you are opening yourself up to criticism and hyperbole, and particularly in politics. So it's just kind of the cost of doing business. I'm a limited public figure in some arenas here in Minnesota. I get defamed.
You are.
I get defamed constantly, and there's jack shit I could do about it, because one is that it's I have to accept, by entering in the public sphere in certain arenas, that I'm going to be opened up to criticism and hyperbole and critique and parody. That's just the cost of doing business. And two is, these fuckers on the internet haven't cost me anything. It's like it doesn't actually result in any damages.
They just get trolling from me on all their personal pages. They do. Yes, I'm out here in these streets defending law. Listen, I'm just saying, like, we're just, as your press officer, we're just going to do all future things at a gun range. It'll solve all the problems, Law. We got this, okay?
I have one more question for Law. During Discovery, if this would have went into Discovery, would the Guardian or the Atlantic have to give up their sources, or could they still remain confidential?
So there's a couple things. Before you get to Discovery, you have to overcome a motion to dismiss, and that's in cases like this, that's usually where they go to unalive, because the plaintiff failed to overcome any burdens of free speech. So they probably won't get to Discovery. Generally, the Atlantic won't be required to disclose their identities. I've had this with some organizational lawsuits that I've done, is where when the respondent, in my case the government, challenges that the organization I was representing, that their people were actually members and things like that. The judge just wanted to see it in chambers. So it was something that the judge got to look at. The judge got to see, yes, these are the sources. Yes, they made these statements. And that the Atlantic had a good faith basis for relying on the credibility of those statements. It's not anything that would be disclosed over to Cash Patel. So that would be the most likely outcome if it survives a motion to dismiss.
Okay, I appreciate it. I didn't mean to derail your live cast. I
we're
figured.
wrapping up. You're good.
Dude, we're nerding, so you're all
Uh,
good, buddy.
okay, I figured you guys, or I knew at least you would have some legal insight, and then I didn't know law of the land.
Law
You
of the
represent
wild. Law of the wild.
sorry,
You're good.
law of the law of the wild. Being a lawyer just helped me out.
I
So
occasionally pseudo legally represent Bearded when he's doing dog shit in a friend of mine's server and trying to start a mutiny. And he is the worst client of all time. He will always admit guilt before I get in there and then get mad at me that he already admitted he did it. And I was like, never admit shit. So, yeah.
yeah, I'm learning the Fifth Amendment is my best friend, and I should probably use it more often. But Cass, last night I was dead to rights. They had me dead to rights. I dropped Birdie from the
Cause
live.
you
Everyone,
admitted to shit. God damn it. Shut up. Shut the fuck up. Never talk. You never say shit. I even tried to get you a deal because you tried to admit to it. And they're like, nah, man, he already admitted to everything. And I was like, oh God.
Cass helped me out with a case we just got a dismissal on because that client was fucking perfect. He just shut the fuck up. He just said, "I'm not answering your questions. I'm not talking to you." They tried to hit him with obstruction of legal process, and and then the judge in the granting the motion to dismiss, the memo is just like he doesn't have to talk, and it's not obstruction if he doesn't talk. So shut the fuck up. Every day.
Yes, there's a whole. I'm gonna send you a video by Pot Brothers at Law. They're also on the app. You should go watch them. They tell you what to do if you get pulled over. Officer, how was your day? I'm not answering questions about my day, and shut the fuck up. Like that's the number one thing you do. If you don't have to do it, like if you get pulled over while you're driving, you probably have to give them the license. But beyond that, don't answer anything. Just be like, I'm not discussing my day. Am I free to go? Shut the fuck up. That's all you got to do. It's so beautiful.
I'm gonna remember that. Cass, if I ever get into real legal trouble, I'll call you. You can represent me real quick.
Don't. I'm not an attorney and in no way authorized to give any kind of legal advice at all. I just fucking work here, man.
Thanks.
Yes, Law. Hold on. How do I put you in? Can you put yourself in the big box? I don't know how to fucking.
Let me see if I can. Let's see. So here's my on the back of my business card.
Okay, so I will identify myself only if the law requires. I will not answer their questions. I choose to remain silent and will not answer any questions until I've spoken with my attorney. I will not consent to searches, seizures, or tests until I have spoken to my attorney. Amen, law. I do not waive any of my constitutional or statutory rights. If I'm not under arrest, I wish to leave. I love that so much. That's beautiful. You got to send me some business cards, Pookie. Okay, I finally figured out how to do it. I don't know how to operate TikTok fucking Studio. I swear to God.
Studio is so weird.
I don't even know how to share the live on TikTok Studio. Like sometimes I'll start on here and I'll be like, oh, well, let me send it over to Law. And then I have to have like Ari or somebody send it to you because it doesn't let me share anything on here. And I'm just like, I hate it here. But it's much easier for this type of stuff because I can put all the things and do the layout. But yeah. Boxer Mom, do they get upset when you show it?
So I've had clients actually show this to police officers, and I haven't seen any body camera footage or anything, but they've always either gotten off with a warning or just gotten a ticket and got sent on their way. it's I think it's effective. When you're talking about things like field sobriety tests and things like that, the only thing you're doing is telling on yourself. Is by that point the officer has already made a decision that they're likely going to arrest you, and they will tell you something like, well, if you don't do these tests, then I have to go on my observations. You're like, good bitch, that's what I want. I don't want to give you any evidence against me. And I can't tell you how many times that I have embarrassed a cop on the stand for messing up the field sobriety test by not following the appropriate steps.
And I want to just say this. Look, so like I'm in Texas, and like if you refuse, they're going to get a court order to do a blood draw. The longer you wait, the lower your content goes down. I'm not saying you should do that. I'm not saying you should be out here doing anything like that, but I'm just saying you got a little bit more time. I'm not saying it's going to be a lot of time. I'm not saying it's going to be ridiculous.
Right. Well, like in Minecraft, if you were to get pulled over by a village chief, and he suspects you of DWI, if you had your window cracked just a crack, just enough to be able to hear him and allow him to hear you, if you kept facing forward and so that he didn't have an opportunity to get a clear smell of your breath, and then you hand over your license, you decline to discuss the events of your night. When he asks you where you're going, if you've had anything to drink, where you're coming from, you say, officer, I respect you're doing your job here, but I'm not going to discuss my evening. They have very thin reason to even ask you to get out of the vehicle. Then if they ask you to get out of the vehicle, they're going to say that they smelled something, which becomes a little bit more difficult for them to claim if it's out in the open air. And then if you don't submit to the testing, they have to go and explain to the judge, if you have a competent attorney who challenges it, what exactly led them to have sufficient probable cause to believe that you were intoxicated when they likely couldn't smell the inside of your vehicle, when they had no information given that you were coming back from a bar, that you had 2 or 3 drinks. None of those admissions exist when you stepped out of the car into the open air, how the officer was able to smell anything on your breath when you weren't talking. And then when you decline to do any field sobriety tests, they're going to have to justify not only the expansion of the stop, but how they had probable cause. So, don't tell on yourself.
I'm just going to say this, and take it for what you will. I'm a type 1 diabetic, and 2 things I can say. Sometimes, depending on our blood sugar and other things like that, we can have a more fruity or even alcoholic smelling breath.
Ketoacidosis.
I'm sorry, what?
Oh, I just said ketoacidosis.
Mm-hmm. And then also, just fun fact, if you happen to be pulled over and you just tell them, I'm really on my way to the convenience store, my blood sugar's low and I don't think I'm going to make it, sometimes they'll escort you there and you don't get a ticket. So, in Minecraft, I'm just saying it works. Just funsies and not advice at all. It just,
shit, it's 1:25. I gotta go.
Okay. All right. I gotta go too. Bye, love. Thank you. All right, guys, I am gonna head out. Thank you so much, all of you, for being here. I'm trying to get a schedule out for landmark cases, which are gonna be in the evening because it's easier for me to do these in the evening with y'all. We're gonna start on landmark cases, probably try to start in June. And then I'm going to try. If anybody has any experience with AI or getting AI to do things, I would like AI to do Brown v. Board of Education for me as a verbal oral argument, so I don't have to sit here and read it to y'all. but we're going to start landmark cases on like Loving v. Virginia, Brown v. Board of Education, Roe v. Wade, Dobbs, Heller, Bruin, McDonald. We're going to be going through a lot of stuff like we're going to do Second Amendment, we're going to do racism, we're going to do a lot of cases pertaining to those things. And that's why I want to start doing landmark cases on those. So if you have AI experience, are really knowledgeable on how to do prompts and stuff, please hit me up in a DM. I will absolutely message you back. Because Brown v. Board is the one that I need, but I'm going to have to create it myself. So anyway, that being said, thank you all so much for being here. You are amazing, and I love you all. Bye, guys.